Legality attentive data scientists, or LEADs, as we call our project funded by the European Union under the Marie Curie program, is a program in which we are training and developing the tools to train a new generation of data scientists, or better said, of scientists and facilitators in the digital worlds in a cross-disciplinary way. What we are doing is to train this generation to be able to bridge competencies from social sciences and so-called art sciences, data sciences, economy, and being able to establish dialogue among these disciplines, because it is needed. And that's what we are doing with a number of innovative tools and approaches built over time. It might be nice to mention at least one, which is the key here, which is the technology innovation in law, the TILs, which are a blended approach of horizontal and vertical training, in which after basically more than 2 years and 3 years in the project at all, the ESRs are faced with a challenge from our partner. So for instance, they are challenged with to solve a problem for a company or for a regulatory authority. They gather in groups, they have to research quickly and study and come up with a solution that can solve the problem, looking at what is the impact of their solution, their limitation, and all the rest. And they are forced to do in a small amount of time, bringing together exactly their different expertise. So the groups are mixed, so there are people with a legal background, with a technological background, or AI data science, or on cybersecurity, for instance, and they have to address in a broad way and solve this challenge, this problem.
So, hello everybody, I'm Arianna Rossi, I'm a researcher at the University of Luxembourg, ESMT, and I'm one of the senior researchers working on LEADs. So I was involved in the organization of this TIL 1 and 2, so I'm going to tell you a little bit about how this worked out today. We had a few steps that we really advised the ESRs to follow, so a little bit of structure, so to say, to get to the solution. As you know, the ESRs had different use cases that they needed to try to solve. And given the fact that they had a very limited time frame to solve them, we decided that it was going to be very useful to do some background research in advance. So they had not so long, actually, they had like 1 or 2 weeks to look into the specifics, for example, in terms of legal requirements or court cases, what kind of technical solutions already exist in a certain scenario. And then they came today to the workshop with some ideas already sketched out so that they could share this kind of background information with all the other ESRs. Today, it was the moment in which they really needed to come up with a solution. So how it worked is that, first of all, we organized a brainstorming session divided in groups. This means that it is a moment in which we're not already thinking about the solution. We're thinking about possible ideas that then could be developed into solution. So it's really a generative moment. Okay, so we go for quantity, not quality, and we also try to really be creative because, as you know, this is a laboratory made on innovation. So the creative part is very important. We don't need to reinvent what exists already. We need to come up with something new. After this brainstorming without constraint phase, we need also to select a specific solution, right? So actually, I must admit, it was not super easy. And this is the moment of ideation. So you select one of the ideas among the many, and then you need also to think about how I'm going to present it. So one way to make an idea concrete and tangible is to create a prototype. We didn't have the time, of course, to really come up with a full-fledged solution. It was not the goal of today. Today, it was only the goal of coming up with a prototype. It means really something that is low fidelity, but is able to communicate the idea in a tangible manner, especially to people that were not present in the ideation phase, so especially to the partners, to get the feedback. This serves because you don't want to already go to the final solution if then we understand that actually it does not solve the problem, or it has certain flaws. So before the actual implementation, we come up with what is called a draft, right? So a prototype. And this, I think, they were interesting also, let's say, we could see, how do you say that? We could see how there is a difference also in terms of mindset and education, and people that have more of a computer science background, I would say, and people that have more legal background. So it was an interesting collaborative exercise, so to say, not very easy. So after that, we have decided on a prototype and created a prototype. It could be a sketch. We're going to see it later. I still don't know. It could be, I don't know, a wireframe. It could be a schema. It could be a blog post. We don't know yet. So it could be many different things. Then another important part of the deal was, how do you present this solution to the partners, especially. So for the presentation to the partners, they also are very open to any kind of presentation modality they might want to use. They may go for more classical presentations by using slides, but I could also do a role play. They could show a video. We will see later what comes out of it. But the evaluation of this prototype is going to be based on its clarity and relevance, and also on how it is presented. So on the actual solution itself and the presentation modality. So we will see what this, where we're going to get at the end of the day. Now, speaking about our use case. So as you know, there were 2 mentors assigned for each use case and each team. I was working on the case that has been provided by Tello, which is about health data in general. And specifically, it is about health data sharing in a way that is secure, is private, and also usable. This is in the wider framework of the European health data space, in which we envision, or at least the Europe envisions, that there's going to be a time, not very far away from now, in which we're going to be able to very easily share data across member states or across institutions. So of course there are a lot of challenges there. So what we did first was that we mapped out all the legal requirements and the technical requirements, and also more of the user needs. And this is interesting because there are a lot of different users that could come into play. So we needed to focus only on a few, because of course in one day it's impossible to solve the whole problem, right? So we focused, for example, on patients that would like to share their electronic health record with a certain subset of stakeholders. And we focus on a very specific use case, or let's say scenario, in which there is an emergency. And the patient may be conscious or may be unconscious. So what happens if there is the need, though, to share, for example, his latest health results with certain people? That could be a practitioner, so the medical practitioner. It could be a nurse. It could be the personnel of the ambulance. It could be the next of kin. So according to the role that different people have in this scenario, they need to access certain data, but not other kinds of data. Or they may need to perform certain operations, for example, to modify the data or erase the data. So according to this scenario, we try to sketch out what are the different security requirements, for example. So how do you authenticate access? How do you make sure that only the right people have access to that data for a specific period of time? We also are looking at the usability part, so to say, because there needs to be notification about that. There needs to be also consent about certain permissions. And how do you do that in a way that is user-friendly, so to say?
Hi, my name is İmge Özcan. I'm a researcher at VUB LSTS, one of the beneficiaries of the LEASE project. And I'm one of the co-organizers of the TIL Technology and Law Laboratories workshop. While organizing this workshop, we had mostly pedagogical questions in mind. How to go beyond conventional learning practices, how do we reconcile different vocabularies and practices around technology and law. How do we support the ESRs in asking the right questions and being creative while working on practical cases? So yeah, these questions were our point of departure, and we got use cases from 3 project partners, namely Indra, Telu, and AGCM. Indra provided a case on biometrics deployment in security systems. Telu provided a case on health personnel access to e-health data, and finally AGCM provided a case on data portability. We let the ESRs choose the cases they want to work on, and they split into groups and formed multidisciplinary teams composed of both legal scholars and computer scientists. And they are also supported by a group of mentors while they're working on these practical cases. In the morning, we have breakout sessions where they do the work, the hands-on work, and in the afternoon, there is an interactive session where they will present their findings. We hope the SARS will find this learning experience enjoyable and useful.
Welcome to the TILS project of the LEADS European project regarding attentive data scientists. I'm Emanuel Vajcek. I'm a scientific officer at the Italian Competition Authority. My background is in computer science and on big data. I'm also a professor at the University where I teach artificial intelligence and machine learning. During the LEADS project, I delivered a practical case study concerned to my field of expertise, and this case study was inspired from a real proceeding that the Italian Competition Authority is performing. The proceeding is about data portability. Well, one of the main gatekeepers, large platforms that deals with search, email services, navigation system services, and many other services that are used over the internet, is acquiring big data, is acquiring personal data from the users, from its customers, and its business model relies on selling those data in an aggregated form to advertisers. From the value of data of the customers, he earns the money to put forward his business. What happened? Small Italian firms that deals with data protection, privacy preserving, wanted to interface its system with the system of this large platform in order to analyze which data was acquired by the platform, how this data was monetized, sold, how was it sold, and wants to, in compliance with the GDPR, Article 20, perform for the user a data portability service, that is, maybe modify the data, cancel the data, or just acquire the data and sell it to third-party customers in order to earn something from those data to the customer that he represents. How did it work? The customers just give a consent to this third party to request their data to the platform, and the small company acquired the data and then tried to monetize this data from advertisers and other parties in order to to earn for the user some value from the data. But the big platform is suspected to stop and not to hinder this process by not releasing automated services for doing this extraction. The extraction can be done manually by the user, but not by a third party as this small firm. So I propose to the early stage researcher and PhD student to solve the case. How would they intervene if there would be an authority, a privacy authority or competition authorities? What are the aspects to consider regarding competition, but also regarding privacy and personal data protection? All these questions will be addressed in this resolution of this practical case. And a great debate will be performed by the student and evaluated by the partners and their supervisors and academic supervisors. So I thank the organizers of the LEADS project, and I'm happy to hear how the students will solve this case.
Hi, my name is Tuborg. I'm from Norway, and I represent Telu. Telu is a Norwegian company, and we are partners for this project. And we came with a problem statement for today's workshop. And just a bit about our company. Telu is a provider of platform as a service and software as a service, and our solutions are mainly for health sector, health personnel. And the problem statement is about granularity of access controls in our solutions. Our DevOps struggling in defining the thresholds for session length, for example, and also defining the roles. So, for example, if we take a health personnel who needs access to all health data for one patient, and for example, he has a role, and in his role on a daily basis, he doesn't need so much access. And so, in some cases, for example, emergency, this person might need more access. And also, if you think about emergency, and if you have to authenticate yourself every time, is it good enough? Or because our customers challenge us, the users at our customers, so the health personnel, they want to have the longest possible session time. However, we have to implement privacy by design, and we in my role, I'm a privacy officer and chief security officer in Telu, and in my role, I want to reduce the session length.
Hello everyone, this is Claudia, my colleague Jose Francisco, and we both work in Intra in Digital Labs, and we are part of the LEADS project. So we have come to Toulouse to see how the ESRs are going to resolve the challenges proposed, and we are really pleased to have the opportunity to talk to them and resolve the questions that may arise.
We are expecting that the ESR resolve the challenge proposed from Indra based on a legal and IT framework. The ESR level has been above our expectation before, so we are willing to see the presentations.
So, did the ECR resolve the case as expected from our side? Well, the ESRs were magnific during their presentations, and they used the framework expected from our side, and they also resolved the questions and were able to be concise and clear about the bullet points.
So we are really pleased we have participated in this workshop, and we've been able to talk directly to the ESR. We hope we can still continue participating in these initiatives. Thank you for hosting us.
Thank you.
I'm Gabriele from the University of Luxembourg. I'm the mentor of the deals proposed by Indra. It was a very interesting use case concerning how to secure an organization that has to handle very private and confidential information. They want to use biometrics for access control to physical spaces. I think the whole experience was great. The ESRs really went deep into the problem, and they explored solutions from the legal side and from the technical side. And I think not only them have learned how to address complex cases like this, but also us as mentor. I was mentoring with a colleague, Gloria, from the UB. I think we also learn a lot ourselves from the experience. So great, we have to do another experience like that.
The pleasure to participate in elaboration of one case, AGCM1 case, which was about the abuse of dominant position by Apple. The 4 people participating in the teamwork were absolutely perfect and really understood the case and the legal and technological items. I must emphasize that the legal knowledge and technological knowledge and awareness was really perfectly balanced, and the understanding of legal issues by technological, so people with technological background as well as opposites, so understanding of technological issues by people with legal background was incredible, and I must say that people made a really big advance during these 2 years of this project.